fellow lawyer and professional. Kim, how are you?
I'm good, Gary. How are you today?
I'm doing great. Thanks so much for coming on our Ask the Lawyer show we do on Wednesdays at 3 p.m. Ever when the corona hit, people can't communicate as much as they used to be able to do. So what we started to do is do this little thing, and then it kind of evolved, and I started having guests, and now I've really classed it up because I have you. Um,
Try to stay classy. Stay
right.
classy, St. Louis. Remember that's from that crazy movie.
With the guy from Saturday Night Live with the chest hair,
Yes.
Mike Myers. Uh,
No. All right, we're showing our age here. Just forget it. It's a
all right. Well, we'll think about it and we'll say it in a little bit. So Kim is
Will
a media.
Ferrell. Will Ferrell. That's it.
Will Ferrell. Yeah, just stay classy, San Diego.
Right.
Uh,
Anchorman.
Ron Burgundy.
Ron
Um,
Burgundy. That Gary, this is my brain. You've just seen it in action. It's there. It's there. It's
oh,
just
it's more than there because Kim is for people.
front.
Kim is fun and smart and witty, but Kim is also an amazing mediator. Kim Kern, law.com is a website. She works for USANM, United States Arbitration and Mediation. I'm excited to have you. We've done a lot of different guests and different topics, Kim, but I was thinking about mediation and talking about it, and I wanted to bring on someone who is an expert, and you are it. So thanks for coming. Um,
Thank you. I'm really
let's do
happy.
some. Say it. Sorry, I interrupted you.
I said, thank you, Gary. I'm really happy to be here.
So, tell me, how do we know each other?
I was thinking about that. I believe that you and I have something in common. We both love your mother because I think that's how we know each other.
That's
she,
great.
she joined USANM when she came off the bench, and I don't know if we joined around the same time or maybe I had been there a little bit earlier, but um, she and I did a presentation together on mediation for BAMSL, the Bar Association, and next thing I knew, you were moving your office into the 500 North Broadway office, where USANM has its office, and you as well. So we're professional next door neighbors. And then we did mediate. Well, we've done several mediations together, but we did a mediation together. So that's how we know one another, is through your mom.
Absolutely. My mom is great. Joan Berger. Joan's a former lawyer, former judge, then went into the mediation work that she does so great. She's a mediator too, along with all the folks over there. So it's great. It's so much fun. My mom has helped in my firm as well, and I've been blessed to practice with her some, and so it's been great. So Kim, tell me, uh, can you explain to us what is mediation? Can you tell me what is mediation?
Sure. Um, Mediation, in a legal sense, is when two parties who have a dispute, sometimes it might be more than two parties, but two parties have a dispute, and they decide that they would like to talk about trying to resolve the case prior to sending the case to a judge and a jury for a decision. And it's voluntary, usually, meaning that whatever settlement there is, sorry, we're having a technical issue. Yes.
Just a little louder. I tend to be loud, and you're like all about mediation and resolving stuff. So you have this softer, great energy voice, and so let me. And I'm also old. I can't hear as well. So
Okay, I'll try to make sure I keep my voice up.
you're
Um,
great. So you're resolving disputes.
yeah, yeah. So what we're trying to do is get the lawyers and the parties together. These days it's by Zoom, but get the parties together to talk about what are the strengths of the case, and what are its weaknesses, and see if we can't find some resolution, that everybody can live with. You're not going to be happy at the end of a mediation. And I tell the parties that every time, and they look at me like, come on, I came here to win. I want to, get everything I wanted and more. I want my pound of flesh. And I tell them, mediation is, is not about everybody winning. And in fact, at the end of the day, if we're successful, you probably are not going to be happy. You're probably not going to be satisfied with what happened. Because every time I went to a mediation, and one of the things that I think makes me a particularly effective mediator is that I practiced law with a plaintiff's firm for a period of time, but I also spent, oh my gosh, more than 20 years on the defense side, both in big law firms, but in-house as well. So every time I went to a mediation, if I went on behalf of a defendant and we were successful at the end of the day, I was like, oh my God, I can't believe we paid that much money. On the
That's exactly. No, that's great. And that's, I've used you as a mediator, and you have that both the balance. And as a lawyer going into a mediation, I don't want someone who is pro plaintiff and is on my side, because that's already me. I'm already drinking the water. I'm already there. In fact, I'm past there. What I need is someone like you, more measured, more neutral, who can tell me if I'm, Gary, that's a good point, but what's the jury really going to think? But is also able to communicate to the other side. So it's interesting how what you need in your history and your experience to make you ready to be that effective neutral. Is that what you're communicating to us?
Yes. And I think there's one thing that I have that most mediators don't, which is I spent more than a dozen years in-house. And when you're in-house, you look at a dispute totally differently. You're, number one, you're paying, you're seeing the money that's being paid to the defense lawyer. So it's different in that sense. But it's also different in that the clients that I saw and were helping through a piece of litigation sometimes were my friends, and when the case ended, I was sitting next to them or at the table next to them at the dining, cafeteria at the university. And you think about the difference. I mean, when you're a lawyer and you finish a case on behalf of a client, usually the client goes one direction and you go the other direction, and they say, nice working with you. Hope I never have to see you again. But it's okay. I mean, disputes they're not fun, but we live in a complicated world with lots of, complicated before us, and disputes are going to arise.
What do you mean when I say this to clients? I've heard you say it and other people. Well, let me say, the first case you mediated for me, you will not remember, it's a long time ago, it was a medical malpractice case, and you were really effective because it was against a big hospital, and you were able to talk their talk, and we resolved that case. Yeah. I am still friends with that client on Facebook and other places. She's a great lady.
Oh, good.
I won't be. There was confidentiality in that case, so I won't say what the issue was, but I will let you know that to this day, she uses some of the money from that settlement to put up billboards and to do other things to raise awareness of the medical condition that was at issue in this case. People talk about that at mediation, but it really happened with her.
I love that. I get people all the time, especially younger people, when we settle a case. If they tell me, well, I'm going to use this money to enroll in college next semester, for example, I'll make sure I tell the defendants that, because many times they're loath to pay money, but they feel a little better about it when they know that the money is going to go for some good cause, like maybe educating this plaintiff and maybe putting them in a better economic situation.
Kim, what makes a lawyer, like, let's say I'm coming to mediate a case with you, what makes a lawyer successful at mediation?
Preparation. I know it sounds so boring. She's saying the same thing everybody says, but preparation, knowing your case, knowing your client, making sure you prep your client. Here, I'll tell you one thing that happens that is not good. The client comes in, the client hears their lawyer say, yeah, we're demanding, $500,000 and here's why. And then the lawyer goes through all the reasons why it's a $500,000 case. So the client hears that and says, yeah, I want $500,000 for this case. Well, we're negotiating. That's your starting point. You're only going one way from there. And on a plaintiff side, it's down. So you have to prep your client to say, look, we're negotiating and these numbers have to be flexible. You have to know that you're going to come down off those numbers or come up off those numbers, when you're on the defense side. So
I see that. And, I literally had mediations 2 days ago and I've been talking with clients and I tell the client, you're not going to like what I'm going to hear, but I don't want the first time you hear something from me to be in a mediation. I want the client to hear that before so that they get it. And I like to have that candor and rapport with my clients. Similarly, more and more when I do it used to be when we did mediation statements. So when I go to a mediation with you, I send you a long letter explaining the whole case and give you exhibits and documents or pictures or whatever. More and more, I give that to the other side too. And I give it to them way ahead of time so they can talk to their adjusters and get the level of authority they need as they go up the chain. What do you think of those two practices that I do?
Not only do I think that is an excellent practice, but I try to convince more lawyers to do that. And the reason why is you don't want to hear those best arguments and those dollars at the mediation for the first time, because mediation is all about expectation. What is it you expect to happen during this session? And, if your expectation is that this person is, going to be unable to work for 2 years, let's say, and in reality, it's more like 5 years, well, the defendant needs time to adapt to that new factual scenario. If you bring that up in the mediation for the first time, you have severely limited your chance to be successful that day at mediation. I'm not saying it might not settle, a month later or 6 months later. But if you want the best chance to settle that day, give your opponent, all the ammunition you can give before the mediation.
So, Kim, what we're talking about too, and I don't want to get ahead of ourselves, is mediating civil disputes. So when one party sues another, you're talking about resolving that. And, I don't know what the latest studies are, but 90+% of cases settle without trial. So this becomes a real mediation, and efficient conflict resolution becomes more important. 2 questions for you. Has mediation waxed or waned in terms of its importance in the last 3-ish years? And we can also talk about COVID and Corona and the pandemic. And 2 is, what percentage of cases that you mediate get resolved, if you don't mind me cutting to the chase?
Well, 100%, because I'm super good. I wish I could say that.
You're almost as modest as me.
Yeah, exactly. A lot gets settled. I think I have a terrific success rate. And part of that is because I'm only mediating and arbitrating. I'm not practicing law. I'm not retired. I do this full time. And I think partly because I do it and do it a lot, I do have good success. And then I'd say maybe, though, another thing that at least I believe good mediators do, and it's certainly my practice, is I believe in a lot of follow-up, calling it. I don't ever let the case die that day. I mean, it's always, okay, what can we do? Hold your offers open. Can we do a mediator's number? Do you want to consider a high-low? How about I follow up with you in 30 days? To try to make sure that there's an ongoing conversation. And I'll have a lot of success with that. So
we're getting into advanced stuff. I want to turn to questions that are coming up on our feed, because I call it Ask a Lawyer, and I do want to ask what people do. But tell me, what is a high-low? What is a mediator's number? What's bracketing? What are you talking about there?
Yeah. The mediator's number is really effective. So let's say you get to the end of the day and the defendant has offered $50,000 and the plaintiff has demanded $100,000. And we've mediated for hours and hours and hours, and both have told me there's no way I'm ever moving. This is it. So I will ask the parties, would you entertain a mediator's number, which is a number that I believe it's going to take to settle the case? It's not what I think your case is worth. It's not an assessment by me of, any kind of a like fair market value or something like that. Because cases really have a range. They don't have a specific dollar amount. And if the parties say yes, I would entertain that. Then I propose a number, and in this case, it would most likely be 75,000. Unless there's some extraordinary, and sometimes I don't just go right in the middle, but sometimes right in the middle is good. So I would propose $75,000, and I would tell both sides privately that you can accept or reject, but if you accept, I am not going to tell the other side unless you both accept.
This is good. So this brings us to a question. I get you. So there's a question. Kelly asks us, what's the difference between mediation and simply negotiating? Which is, I thought of that because that's kind of what you were just talking, and I know I interrupt you, I apologize, but what you're just talking about gets to that issue. Is that, so can you answer that question, the difference between negotiating and mediating?
Yeah, and Gary, when I started practicing law 35 years ago, can't believe that. I don't think there were, I don't know, if there were professional mediators, I'd never encountered any. We did just negotiate our own cases. And we were very successful at it, but there were times where the personalities would cause a breakdown, or maybe, I remember I had one case where the defense lawyer told me point blank, I refuse to talk to that other side. I find him to be a heinous individual. So I was the mouthpiece. This is way before I ever became a mediator, which is kind of funny. So why mediation is different than negotiation is the mediator is a professionally trained negotiator who comes in with a whole bag of tricks, and maybe tricks is a bad word, a whole bag of strategies and techniques that have been proven over time to be effective. And one of them, for example, is this mediator's number. And so, I'm kind of the go-between. I'm the Henry Kissinger of disputes. So the
Very
thing
good.
I love about the mediator's number is, so let's say on the defendant's side, you're willing to pay 75. The plaintiff never finds out that you're willing to pay 75 if the plaintiff said no. And both sides really like that because it gives them some comfort, some cushion. And then, we decide what we want to do. If we don't get a deal because of the mediator's number, there's still ways to talk and ways to keep it going. So
well, and then the mediator's number, you've tested the waters, you have a feeling and you have a gut on where this thing's going, and you speed things along and get to a resolution, which is the other thing. And, the other fundamental difference between the two is negotiation is party versus party. Mediation is party versus party, but you're in the middle. And so that's, the mediator is the person between the conflicts. What is, Adam asks, what's the most common reason clients give as a reason they don't think a mediation would work in their case? And then how do you respond to that? What do you say? So what's the most common impediment to going into a mediation, and what's the answer?
Well, I tell people all the time, if I only mediated cases in which the parties came to me and said, yeah, this is going to settle, we're going to get this done, I would have 0 cases. Every single case that comes to me, they say, we've tried to work it out. We can't. This is never going to settle. It's funny. When they come to me and say, we're pretty sure this is going to settle, that's when I start worrying because I think, the
kiss of death.
So I think the most common reason the parties give for why they think mediation is going to fail is, they've maybe already had some discussions, and there's a lot of emotion involved, and sometimes the one side really dislikes the other side. Something bad has happened, and there's so many different kinds of cases. So when you do a car accident, for example, plaintiff and defendant have never met each other before, and they're not going to have an ongoing relationship after the lawsuit. Their cars crashed. It's over. We just have to talk about the money. But there are so many disputes where, that's not the case.
So what's your answer to the question of what do you tell those folks? Is it that, listen, mediation works when parties can be polar opposites. If people resolve disputes in intractable disputes, you can imagine if they can resolve that, they can resolve your case.
Gary, I have seen miracles. I don't know how else to say it. I've seen miracles. I've seen people come in so entrenched in their position, and they work through it. Some of it is being heard. A lot of times the plaintiff feels like nobody cares about my complaint. Nobody cares, about what happened to me. Nobody wants to hear it. And mediation, a lot of times you will have these very important people sitting around a room listening to your story, listening to what you're complaining about, and doing something about it. And that's powerful. So I think you have to come in. What I tell people when they tell me like, oh, the mediation is never going to work, is why not give it a shot? Maybe the court has ordered it, so why not try? And I tell them, I have seen cases settle that I would have bet a lot of money there's no way this is going to settle. At like 2:00 in the afternoon, you get this is not going well. And then sure enough, 4:00, things are looking good. 5:00, we're signing a deal.
Great answer. Great answer. What about, well, let me go to another question I read here. We're talking about mediation in the context of resolving civil disputes, but Maya asks, how can mediation be used to solve community issues or community disputes, homelessness, environmental issues, or all the other issues we have? We have a very it seems like our country is at each other's throats. Americans are fighting each other, and the issues that divide us are being exaggerated more than the issues that unite us. And I don't want to get into the politics of that today, but this is a great question. What about mediation in non-civil litigation areas?
Yeah, I love that, Gary. I feel that way too. In fact, I think that's part of why I became a mediator. Is I'm a peacemaker, and I don't want to sound, I don't mean to sound theological or whatever, but I do really want to find peace in my life, but in my world. And so I've done some really interesting community mediation. I mediated a case one time between neighbors and a local school, and the neighbors were very unhappy. It was a residential school, and the neighbors were very unhappy with how the teenage boys in this residential school were behaving. And I'm the mother of two young men, so I can appreciate sometimes what they, put their parents and their neighborhoods through. And it was a really cool thing. We held it at the school after, like at 6:00 in the evening. We invited everybody, and we had 30 or 40 people, and we had a very kind of orderly setup, and took questions, introduced everybody. And, I don't know that we solved every problem that the school had, but we certainly opened up communication. And I know there were people at the end of that session who felt validated, whose concerns were, the director, the principal of the school listened. And that can be very powerful.
Thank you. What about, so I happen to, know you and the organization, and one of the great things that you all do at USA&M is you and Rob Litz and Mike Geigerman, you have this not-for-profit where you try to address and solve housing issues in the city and the county. And we're especially reading about this now. People are losing jobs, can't pay rent. There's been either through courts closing or judges taking their own action, stopping evictions, or also federal mandates, although I'm not clear about their power over state courts. I'm not really clear. But there's kind of been a stopping. Let's not toss people out of their homes at this time. And then on the other side, and I know I'm talking for a minute, but then on the other side, I also have friends who are landlords who are like, yeah, but do I have to give this apartment or something to someone for free? And they're like, yeah, they're collecting unemployment. They're getting checks. They're spending the money. I see the Amazon boxes on their doorstep, and they're not paying me my rent. So, and I'm not saying everybody's like that or trying to paint with too broad a brush. Can you talk to us about that not-for-profit and trying to resolve those issues?
Yes. Actually, this is one of my favorite volunteer projects I've been doing for a couple years. The St. Louis Mediation Project and some others. Karen Tokard, the professor at WashU School of Law, is very involved in this. There's a program both in the city and in the county where we come in and mediate cases between landlords and tenants who are not represented by lawyers. And, Gary, that is exactly the population you were just referring to, where the landlord says, hey, I have to pay property tax. I have to pay bills too. And many times it's not this uneven bargaining power that you might think. In fact, a lot of the landlords and tenants that come to us, sometimes they're friends, sometimes they're even family members, which is very tough to deal. I mediated a case in which one brother was evicting his brother. Those are tough ones where there's a lot of emotion involved, understandably. And so anyway, now in the time of COVID, those programs have continued. And what we try to do is we do it by Zoom, which is definitely a challenge. So all mediations, or 99% of all mediations, have moved to virtual mediations where we're doing them by Zoom. So we have the judge who calls this docket, and we as the mediators and the parties all participate in Zoom mediations. And what we're trying to do is we're trying to address homelessness, because if the person is evicted, many times they will become homeless. So we're trying to work with, where will the tenant go? Is there money out there that maybe could help with the rent that's due? Or if the tenant is going to leave, when are they going to leave? And we find that when we negotiate this eviction, the tenant leaves the property when they say they're going to leave. They leave it in good shape. There's no destruction or trash left behind or something. And we find that the landlord is much more willing to maybe to give the tenant a satisfactory rating or something that helps them get their next place to live. And it's a super fun project, and I can't wait for us to get back together in person because they're more effective in person. But we're doing it the best we can. And in fact, what we're doing now up in North County is we have a couple big apartment complexes that have agreed to mediate pre-litigation. So they haven't filed any eviction, proceeding yet. So they haven't spent the money, on the filing fee. And we're working with the landlord and the tenant to figure out, okay, is there some CARES Act money? Because CARES Act is the name of the federal law that's trying to get some money into tenant and landlord hands to help people from becoming homeless. And to work with them on how can we solve this problem. So it's been really interesting. I had a tenant who was COVID positive one time, and we talked about how she was feeling and what that meant for the apartment complex. And I mean, these are life and death issues.
Yeah. Yeah, Karen Tokars is one of my favorite. I'm a WashU grad, one of my favorite professors and a friend for probably the 20 plus years, 28 years or whatever. I've been out for law school for a while. She's fantastic. I love the combo between the academia and the professionals like you guys at USAM. I know you guys use students. You do a whole thing. It's a whole approach. It's an amazing project. How has let me move on to another question we have. What about, let's talk a little bit about mediating in the days of COVID. You just touched on it. Zoom mediations, not in person. I have found them to be just as effective. I think everybody's had to adjust. For me, it was a little rocky. I did an argument to the Missouri Supreme Court, and they had to tell me to turn my mic on when I began, and then you tell this you do this, and then at one point I was like, I can't see my clock on the screen, and so I think I argued it fine. But talk to us. What you don't have the personal touch in terms of physically being there, but I can tell just listening to you talk right now, the level of care and the level of truly caring about issues and this stuff. It comes through on the video just like it would because I know you in real life. But what are the differences? What are the challenges? How are you getting around those or over those?
Thanks, Gary. That's really nice of you to say. I have done at this point since March over 50 Zoom mediations. I have done a lot. And that's not the landlord-tenant ones. These are cases with lawyers, with, lots of issues. One of the things that Zoom has done for me that's kind of interesting is I've been getting all these cases from Chicago, Springfield, Illinois, because I practiced in Illinois for a long time as well as Missouri. So that part's been kind of nice. I have all these lawyers in Chicago now that I'm working with. So Zoom is clumsy. You certainly have to struggle to get that, to exude that warmth and that connection with everybody. I try to do it with a combination of some humor, but also some, things I have in the background. In fact, hold on, I want to show you something funny. This is not mine, but I love it.
Yep, it's true.
Totally put this in my office.
I'm not in my office, so I don't have all my props. But
yeah, I'm putting it up.
So that's Casey, my paralegal Casey, with me for 9-10ish years, and she is the girl boss. Anybody who knows, I'm kind of the boss, but she's the girl boss, and she gets it done. She is amazing.
I hope you're watching this, Casey. Hi.
Hi, Casey. I did one of these with her. And she's like, I got work to do. I don't got time for this BS, Gary. Come on. So, all right, Casey. Yeah, she's the girl boss. So,
well, Gary, a couple things that I have found on Zoom mediations. One, it's forced me to become a real Zoom guru. And I can talk people through a lot of issues, technical issues that come up on their computer. So I'm pretty proud of that because, I feel like my focus is far more on law and on mediation and the psychology behind mediation, not the technology to support it. So I'm proud that I've been able to pick that up, and I have had everything happen. Yeah, from mics going out to people with unstable Zoom. So here's my best story. We start the mediation, and I noticed that one of the parties is in the cab of a truck, and the truck is moving. Like, you can't mediate while you're driving. You cannot. No.
I've had judge friends of mine in a docket in criminal court with a guy in there on a Zoom driving. He says, "You pull over the side of the road. You can't do it." One of my friends, a judge in the county. Well, you've surmounted those, and this is the new way it is. Just like this, like what we're doing here.
Yeah, yeah.
Got it.
And, I try to find small wins. And I'll tell you, here's one small win. If we are able to get a deal, I pop up that mediated settlement agreement, or on my screen share, if we have the release ready to go, I pop it up on the screen. Everybody sees it. Somebody says, gee, I don't like paragraph 2. Okay, can we remove paragraph 2? Done. And, that has been a really effective tool to get the mediated settlement agreement done faster and with less acrimony.
I do the same thing. I spent 6 hours today on a Zoom deposition where I'm putting up documents and doing. It's just different. There's some challenges, but here, I have this is my question. And so you talked about the psychological issues in mediation. How do you handle risk tolerance in individuals? Because in a mediation, if it is my client, they have one claim, and they can only ever have one claim for these injuries, and it's all or nothing for them.
Yeah.
If for an insurance company who I'm battling, because I represent, they have 1,000 claims. And so my experience is that my clients are less risk tolerant in some ways, and the insurance companies are more risk tolerant. But that's kind of why I come in to equal that risk tolerance, trying to level that playing field. Now, on the other hand, too, sometimes, as you said, you start up with $500,000, as you used that example 15 minutes ago. If a plaintiff sees a number, they may be fixated on that number, and you need to say, listen, that we may be talking about that number, but that's not really cash in hand. So there's a disconnect on that risk tolerance. So what's your wisdom on the risk tolerance issues, or those issues that I've always been fascinated with?
I had a case one time where the plaintiff's lawyer was really pushing his client to take the final number that was on the table. And it was a good number. It was in the range of what this case was worth. And the guy kept, no. And I used the analogy of, look, when you go in front of a jury, and I asked his lawyer, you try this case 10 times. How many times do you win this dollar amount that's on the table right now? And the lawyer was like, maybe 1 in 10. This is a good deal. How many times do you get 0? Probably 5 out of 10. We weren't in a great venue for plaintiffs. And, we were just, the plaintiff's lawyer and I were scratching our heads like, what is going on with this guy? Why is he hesitant? Why is he so recalcitrant to take this? Turns out, guess what his hobby is? Going to the casino. He's a gambler. He loves gambling. And it took, I hate to say this because it really got ugly, but it took the plaintiff's attorney threatening to walk off the case to get it done. And, that's a client control issue, and that happens sometimes. And it really made me laugh, though, like, oh my gosh, I better be careful about that analogy of rolling the dice, because there are some people who want to roll dice. That's what's fun for them. But in law, that's not fun.
Well, and in law, and what I explained to rolling the dice, it's not like red or black on roulette, or whether you can whether you should hit a soft 16 or something. There's so many variables that go in and out, and so you'll explain it, and then the person will say, yeah, but my damages are this, and say, yeah, but remember liability, or the defendant will say this, and you say, listen, yeah, you can say that, but the jury's going to love. So there's so many variables going in and out. It's hard. It's hard to do that. Do you feel that with good plaintiff's counsel, that risk tolerant, and in a case where clients are well prepped and there's client control, that risk tolerance differential is balanced between a big institutional defendant and a single plaintiff? Or is it still not balanced?
I don't think you can generalize, because I've worked with plenty of adjusters and plenty of defendants who really understand the risk and really are making good decisions. I don't find that you can stereotype one side as being risk averse or risk takers. They're very good. I am blessed. I work with lawyers and adjusters who are fantastic. I thought about really no longer practicing law. I think I was out maybe about 20 years or 25 years. And I was leaving. Had been legal counsel at Southern Illinois University, Edwardsville, and I was leaving, and I wasn't sure what do I want to do. And I went to mediation school, and it was 1 week, and I really wanted to learn more about it. And Mike Geigerman at USANM that helped me just to look into it. I didn't have an offer in hand or anything like that, but I went to mediation school, and I loved it, and I had forgotten how smart so many lawyers are who you get to work with, and what delightful people many lawyers are. And there are plenty who aren't. Don't get me wrong. I don't want to, sound Pollyanna-ish, but I'm blessed because so many of the lawyers I work with are smart, they're prepared, they want to be there, they love what they're doing, they're good at what they do, and the better the lawyers, the better I look,
Yeah. No, I get it. Yeah. We got a lot of questions on our feed here, so let me keep moving along.
Good.
I have a question from Hugh. Hugh asks, I've experienced many different styles of opening statement. In one case, this is a counsel, Hugh Eastwood. I may know Hugh, I don't know, but let me just keep reading. You know him?
Yeah.
Good. So Hugh asked, in one case, opposing counsel was highly aggressive and dismissive of our position, handing out a memo and Westlaw printouts of case law. I felt it was solely for the benefit of his own client. Unfortunately for me, my client was smart enough to recognize that. What styles of opening do you find most helpful? I'll let you answer that question, Kim, and then I will also answer.
Oh, good. I always do a caucus first mediation where I talk to both sides before we do any kind of an opening. And I always prep both sides to say, to understand that they're going to hear things they don't like. They're going to hear things they maybe don't agree with. And to let them know this is not, I'm not a judge. I'm not going to be issuing a decision. So please don't interrupt the other side. But it's really important that both sides be heard. But then I also follow up with, and this is maybe more true with the defendants, to make sure that they understand that if they go in with this incendiary language, that they are going to make the plaintiff mad, and they're going to make the plaintiff's lawyer defensive. And is that what we're trying to do today? Because this is a mediation. It's not your opening statement before the jury. And I usually will ask the defendant if they'd consider an apology, So let's say we're doing a car wreck, and the defendant says, I am so sorry this accident happened. I'm so sorry you incurred these injuries. It's in a mediation. This is not going to be able to be used in court. And it lets the plaintiff know that you're a human being, that you have feelings too. And I find that that's extremely effective. I know a lot of defense lawyers are like, no, I'm never going to do that. But I find it really effective if they're willing to do it. So openings, a lot of times in mediations, people don't do openings anymore because of that. They feel like it just sets the stage backwards. But Gary, I do some pre-suit mediations, meaning no lawsuit has been filed, but
and those you got to talk more about the facts and present.
Yeah. So you have to look at where are you in the lawsuit. If you guys have already gone through summary judgment, maybe opening statements really are unnecessary. So you got to look at it.
My experience is, Hugh. So it's interesting. So in the case, one of the many cases you mediated for me, but the first one, they literally brought in the CEO of a hospital and looked across from my client and apologized to her, and he meant it. And he explained to her what the hospital had done to change things so that this would not happen again. And that was powerful and not BS, and it moved and it helped. And I've also had that. I've had this many mediations where they walk in and say, listen, we're going to talk about facts and you're going to hear stuff, but before we get started, you were injured, you suffered a loss, and we're really sorry for that. And I can't tell you how many times I get med-mal leads or other cases where they're like, they want vengeance. They don't, even if they don't have a case. So, to answer Hugh's question more particularly, Hugh, I don't do opening statements anymore. What I do, because it's not going to, me yelling at a claims adjuster, I've already drank the water. I'm already a fighter. I'm fighting for my client. They know that. It doesn't change the game. So what I try to do is I try to so that they're prepped, so that adjuster can go to their bosses and get all their stuff. Is if I'm going to do an opening statement, I put it in writing and I send it to them 2 weeks before. I have literally done PowerPoint presentations where 2 weeks before I will send it to the other side and say, here's all the great stuff from the depots. Here's the picture. Here's the video I did. I'm not going to waste your time and do a dog and pony show in front of a bunch of people so that you feel I have you a captive audience and now you got to listen to some darn plaintiff's lawyer who you don't want to listen to. You already talked to enough more of these people. But here it is. And you digest it because this is what it's going to look like at trial. That way the adjuster gets to see it. They get to digest it. Let them give them their responses. Great. And then let them run it up the chain of command so that they come with plenty of authority. The other thing that does is it shows them respect, that you respect the adjuster and the insurance company's professionals on the other side. So you're just not there to yell at them and berate them. The other thing, let me say one other thing on this issue, if you don't mind, Kim, is one of the other things you got to decide into going to mediation is, do you want to settle your case or not settle your case? Because if you want to settle your case, you should play your cards, right? I mean, how often are you at trial when you really surprise someone? I mean, that's just...
I couldn't agree with you more. And when I have parties that do that, they'll have some piece of evidence that they think is just so outstanding, and they'll say, but don't tell the other side. And I think, well, wait a minute, aren't we here to settle the case? Why would you not want me to tell the other side? You should have told them 2 weeks ago or a month ago before this mediation even started. And the other thing I find is that usually, and this has happened to me, usually the other side already knows it. So you think they don't know, but they know, but they don't want you to know they know. It's like, oh, God.
And if you talk to lawyers who have done this for a while, we know what it's going to look like at trial, or experienced people on the defense side. You're like, listen, you're going to put this evidence in. I'm going to say this. The jury's going to kind of hear this, or the judge is probably going to let this part of it in, but not this part, or blah, blah, blah. So that can be helpful. Moving on, let me move on to another area. I like talking. That's great. So, Kim, here's an interesting question, and this Kelly asks, Breonna Taylor's wrongful death case just settled for $12 million. Meanwhile, the grand jury is still making a decision on whether to arrest and charge the officers involved in her killing. Will this wrongful death settlement have any bearing on that decision? You mind if I've let you go first on a lot of them. You mind if I go first a little bit too on this one?
Go on.
Thank you. So it's interesting. When you have a case with a criminal element and a civil element, I typically I don't want to get in the criminal law's way. So usually we try to, you don't want to jeopardize the criminal case by giving the defense lawyer the chance to say somebody's just in it for money, and so they're affecting their testimony. But here it's done. That case is settled, so maybe that's smart. It's interesting that this wasn't confidential, but I think for some municipalities or cities, they want to settle this stuff and get it by them. Look what's happening in I don't want to talk politics, but look at St. Louis County with that huge great verdict, hardworking gay discrimination case, and then there's another one right now, and that was in the news. And so a lot of times they want to settle these and get beyond them and change the decision makers and do stuff. So I get that. To get to the end, will this wrongful death settlement have any bearing on the decision whether to charge? Well, it may or may not. A grand jury may or may not hear that. They're going to present that evidence to the grand jury, and then it's either 12 or 24 people are going to decide whether to do that. So I'm sure those grand jurors will hear that, even if they get it on Google, because I don't know if you really sequester a grand jury. It's more of a long process, these grand jury things, because they're doing different stuff, and grand juries are usually impaneled for 3 or 4 months out of a time. They'll meet a couple of days a week, or they don't want to take those jurors the entire time. So it could affect it. It also could affect the trial. But trials like that are high-profile trials, in this very, very sad case of Miss Taylor, it's the news on those cases are all out anyway. So anyway, there's my 2 cents a little bit on that, Kim.
I've represented some public entities, and I've mediated some cases with public entities. And a lot of times they really do have confidentiality issues, because they're paying usually they're paying the settlement with taxpayer dollars, and it's public. I mean, many times there are statutes that require it to be public. In Missouri, we have a Sunshine Act that makes it public. In Illinois, for many years, they were private, but then that FOIA law, or Freedom of Information Act law, was changed to make settlement agreements like this public after so much time. So they're public, which makes it really tough, because a lot of times both the plaintiff and the defendant have something. It's good for them for it to be confidential sometimes, not always, but sometimes. But when you're dealing with a public entity, usually it is not confidential. And that is, that's a point we negotiate. That's a point of negotiation in almost every single case I have. And I understand why. You don't want other people to know your business. And, maybe what one case is worth is not what another case is worth. I'm very respectful of that. And I think in these police cases, I think a lot of times the defendant is anxious to put some money in the hands of the plaintiff or the plaintiff's family, because they're suffering. I mean, I'm sure they had to pay money to bury her. They had to pay money, what a sad, the whole thing makes me want to cry. I can't even watch some of this on TV. I swear, I can't watch. It's too upsetting. So
very upsetting to see these videos and to see this continued. It seems like every 3 or 4 months. Those are great points. On the confidentiality, though, there's also a concern among claimants' counsel that if defendants insist on confidentiality, you're stifling public information and you're preventing that. We saw with some of these non-disclosure agreements with some of these sexual predators that, in the last years have been, that's a way to, then people don't know that so-and-so is a predacious person, or you have a company that is violating safety rules and injuring or killing people. The public needs to know that. And then, we want to know, so I fight confidentiality, I think, more than other lawyers do sometimes. You and I have had these discussions before in mediations where I'm like, what? No, I'm not doing that. I want everybody to know. And I need to put it on my website. Or on my newsletter that I do, and I joke about that. And it's not about me, really, but it's also people need to know. I get questions all the time. What is this case worth? What is that worth? Well, the only way you know is by showing what other similar cases have settled for. It's one way to know, unless you want to try it in front of a jury every time and settle it. So
Yeah.
I know every case is different, and I do appreciate that some businesses have a financial interest in keeping that stuff private. But the insurance companies know all the confidential settlements because that goes into their index and stuff. So it's only confidential from the public many times. So to the extent I just would add that on that other concern on confidentiality.
Yeah, I hear you. I think you're right. It has been used to protect some pretty awful sexual predators and some pretty awful actors. And what you hope happens is that when a company, like let's say the whole Roger Ailes case, and there had been multiple cases against him and each one they had paid off, you'd hope that the person paying the money, somebody, the board of directors, somebody, would say, we have paid out millions of dollars because of this guy. Why is he still here? Let's do something about this. That's what frustrates me.
Great. So I'm going to try to go through. We got minutes left. I have a great question. What is a client's role during the mediation and their lawyer's role? A client's really important. They talk to the mediator, and the mediator gets a sense of what their real damages are. And then the lawyer's role is still as the advocate. What I would wanted to move to ask you, and then there's another great question about arbitration that I'll just quickly answer because I want to get to one other question about for you, Kim, to close out. But an arbitration is, tell me if I'm wrong, Kim. So an arbitration is you give up a right often to a jury trial in certain contracts that you sign. So there's mandatory arbitration clauses, which force you to arbitration, and those can be good and bad. There's different sides of it. On the one hand, sometimes the arbitrators are often paid by the industry people, so I always have a concern about that. But on the other hand, in an arbitration, you get to a judgment a lot quicker than you do in a civil case. So, go ahead.
I think, Gary, one of the things people don't realize in arbitration, you get there a lot faster. And there's very, very limited grounds of appeal. So when you have that hearing, man, you finish that hearing, you get your decision in 30 days, boom, you are done. And for a lot of plaintiffs, think about it. I can wait 3 years for my time in front of a judge or a jury, and in days of COVID, maybe 3 years is even optimistic. Or I can do an arbitration, and I've done arbitrations by Zoom now, which has been very interesting, and masked. I did an arbitration in a big couple rooms, everybody wearing masks. Very interesting. But you can get that case started and finished in certainly less than 6 months, maybe 4 months. Maybe that's worth it.
I had a large set of cases, a couple rounds of them against some local and national businesses, some for-profit schools that I sued them. And then they won some motions to compel arbitration. So then later on I had a second set, and I said, fine. And I just filed 20 arbitration cases, and we ended up trying a couple of them and then settling the rest. So there can be those things. So are there, one of the things, so now we have this corona pandemic. I'm at home all the time. One of the blessings that I have appreciated since March is I'm home a lot more, and how well my wife and I get along. And I really have a lot of gratitude for that. And I know you're a devoted, you have a husband and you have a strong family as well. So I'm going to share one thing so my question to you is going to be, are there skills from mediation that you find in life? And how have you, I know you're a person with a lot of gratitude, but how is that? What are those? But before I turn it to you for our last statement, I will share with you my favorite quote from my wife that I may get in trouble for. But one of the ones that I laugh at every once in a while is one time she turned to me and said, "Gary, you are not my life coach." No, I love her to death, Kristen. She's great, and I value. Today I'm in the office all day in depots. There's days I'm home and working from home, and it's a blast. So I really cherish that. So anyway, turn it to you. What do you learn from mediation that you bring to life, and is that affected by or this pandemic?
I think there are absolutely skills from mediation that you can bring into your life, into your home life. And probably, one of the skills I think that's been most effective for me, I told you I have two sons, is the idea of active listening, So I'll give you an example. Gary, how did you feel this morning after you finished your cup of coffee or your cup of tea or whatever you had this morning?
I'm out of here. See ya.
Okay. After you had,
I have teenagers too. No, I'm just being funny. I don't know. I felt fine. I felt ready to greet the day.
Okay. So Gary, if I understand you right, after you had your cup of coffee, you felt fine and you were ready to greet the day. Is that right?
Yes.
Okay. So what I've just done in my active listening is I did two things. One, you were heard, you're validated. What you said, another human being heard, understood, and, parroted back from you. So super important. Secondly, I've had a chance to you have had a chance to correct me. If I heard you incorrectly, now's your time to say, no. I felt terrible. The coffee was bad and I became sick or whatever. And that active listening is really something that I've struggled with because I'm a talker, not a listener. So it's helped me to bring that skill to home, and I think to be a much better wife and much better mother and, just human being. Who wants to just sit and talk all the time? I do want to learn and listen to people. So that's been a good skill for me. And I love hearing that you and your wife have fun at home together. I shout out to my husband, David, of 29 years, who actually came with me this morning or this afternoon because he's not only a lawyer, but he's also my technical assistant. So thank you, David.
Excellent. Thanks, David. Thank you. Well, Kim, I always enjoy talking with you, and I love how you keep it real and go straight to the heart of issues and talk about real stuff, whether it's mediation or anything else. It's really effective. The other talent and we didn't talk about it, but it's separating the wheat from the chaff, and you do that instinctively, and I find that to be an easy way to interact with you.
Yeah. Thank you. Yeah. You know what? I'm all about, let's have real conversations. Let's have meaningful conversations. Because, we're not all here. We're not alive forever. We all have a limited amount of time here. So let's have good, important, meaningful conversations. And that includes, finding some peace in a dispute. Yep.
I agree. Well, listen, I'm going to sign off. Thanks, everybody, for watching Ask a Lawyer this week. Thanks, Kim Kern of USANM. Thanks for coming and talking with us, folks. If Kim is like me, we would always answer questions for free to you. So if you have questions for me, you can always get a hold of me at burgerlaw.com. If you have questions for Kim, you can get a hold of Kim at usanm.com. Or we put her other thing up, kimkernlaw.com. We're the types of folks who always are trying to educate the public and teach people stuff, which is part of the purpose of today's broadcast and all the stuff we do. So thanks, everybody, for listening. And thanks again, Kim.
Thank you.
All right. Bye-bye.
Bye.